Well, good afternoon, everyone, and welcome. We all welcome you to an afternoon where we hope to be able to share and learn quite a bit from each other regarding the Code of Ethics. I'm Marcus Wally, and I'm proud to be a broker and real estate instructor, a Florida realtor from St. Augustine, Florida, and most proud this year to be the chairman for professional standards here for our Florida Association of Realtors. The program this afternoon will be in compliance with the National Association of Realtors' 2.5-hour minimum Code of Ethics presentation, which meets our quadrennial ethics training. As you know, the Board of Directors of the National Association of Realtors have mandated that all new realtors and professional realtors who have been in the business a number of years will get together every 4 years to complete a minimum of 2.5 hours of Code of Ethics training, and today our program will be in compliance with that. We've brought a number of professional friends to help us this afternoon. I'm Marcus Wally and going to be with you for a number of the articles in our history and introduction. We also will have Linda Dix, a longtime Tallahassee realtor, with us, Al Liebert of Miami-Dade County, who is known in our state of Florida as Mr. Ethics. We'll also have from the Florida Association of Realtors staff, attorney Christy Harrington, and Carolyn Gardner, also from the Florida Association of Realtors, who is our local leadership services guide. Our audience is comprised today of a number of instructors that teach the Code of Ethics, and we are glad you are with us this afternoon. As we begin, let's go down the road of some history of the Code of Ethics. A little history of the Code of Ethics begins that in 1908, the National Association of Realtors was formed. At that time, there were no license laws in effect. It was a wild time in the real estate business. We were actually known as peddlers on horseback. Crazy things were happening. People were buying and selling properties that didn't even belong to them. So it was a wild time. We can be so proud today that we are realtors, and our organization was one of the first of the learned groups with doctors and lawyers and engineers to establish a set of conduct for our behavior. The first paragraph of this historic code established 23 ethical obligations, and since then, for all sequence and subsequent versions of the code, those things have been involved. There's a historic paragraph in the code that I'd like to read you. It says, the real estate agent should be absolutely honest, truthful, faithful, and efficient. He should bear in mind that he is an employee, that his client is his employer, and entitled to the best service the real estate agent man can give. His information, his talent, his time, his services, loyalty, confidence, and fidelity. These are all the things that the realtor shall give. The adoption, as I said, of the code took place before many of the states ever had license laws, and it's interesting today that many of our states took the code as a good beginning of how they would create their license laws. Think of the code as the highest and best standards for personal and professional conduct. The code also applies to us as members when we are buying and selling our own property. Realtors in specialty areas may be also subject to various codes in their fields, but the one duty that every realtor has is the strict adherence to the code. Can you imagine our business if we didn't have a set of guidelines that we all followed to protect each other and protect the public? The cornerstone of our organization is this Realtor Code of Ethics. It's what makes us so proud and what sets us apart. Although we compete together, and we do a good job of that, we also work together for the benefit of ourselves and the public. And for the majority of the public, when they are surveyed and asked, what's the most important thing to do to you when you do business with a professional person? they always list the code of ethics as being a quality that they want to see in all of us. From its inception, the code of ethics always required arbitration when there was a monetary dispute between realtors. There's a powerful statement that sets the tone for our industry, and that is, "Under all is the land." This is a powerful statement, and it's something that we know is the beginning and basis of our organization. Ethics, business ethics, how we handle ourselves. Ask any professional person, ask any realtor why their success in real estate has been long-term, and it's due to their behavior. It's due to their adherence to our code. Being successful, helping the public, and walking that fine line of the golden rule is part of the recipe to being successful in our business. We know that in the real estate business, referrals are a large part of our day-to-day operations. Being an ethical realtor allows our consumer to refer us and send friends and family to us. What's that old saying about don't treat people correctly and they'll tell lots and lots of people? But when you do things right, the referrals spread and your business grows, and you're in our business for a long time. Today, there are 17 articles of the Code of Ethics divided into a couple of categories: duties to clients and customers, duties to the public, and duties to our fellow realtors. Each article has a standard of practice which interprets the particular code, and then further, you find case interpretations which give actual situations from hearings on each article. Our Code of Ethics begins with the preamble. It's aspirational, and although no violation can ever be brought up on a realtor due to the preamble, it's important to know about the preamble and what it is. Basically, as many of us learned when we were children, the preamble begins with the golden rule: do unto others as you would have them do unto you. It also calls for the widely allocated ownership and the widest distribution of land ownership. It also states that we are here to maintain and improve the standards of their calling. A couple other important things about our preamble are that we, as realtors, are deemed to always be informed. When we are here to protect the public, we can only protect them when we are knowledgeable about our local community and our industry. We must keep up on our education, as we all do, to remain informed, to give good guidance. Share your expertise. One of the most powerful parts of the Code of Ethics to me is to always be willing to share the fruits of your knowledge to help a fellow realtor. I think many of us who have been in our business for a number of years and are successful contribute our sharing to our success. What do they say about teachers? When you know something and you're able to share it and teach someone else, that's when you've really grasped it. So part of our preamble is also to share that expertise that each and every one of us have. A third part of our preamble says, be careful. Be careful that you don't ever take unfair advantage of a competitor. Today, in our world where we have such good creative marketing and slick ideas that make us individual, there's nothing wrong with that. Just don't take it to the limit where some of those things might be unfair to our competitors. And finally, as that golden rule states, do unto others as we would have them do unto us. I think sometimes if we all followed that golden rule, there wouldn't be a need for a lot of additional laws. As we know, the Code of Ethics is a living, breathing document. In our industry that changes so rapidly, The National Association of Realtors is behind us, and they always keep up with those changes and ensure that the code is updated and cutting edge. You'll notice every January we'll have a revised code of ethics, and it's, I think, something we should always get a copy of. Go to our good website, realtor.org, where you can download a current copy of the code each year. I value this code. It's how I do my business, as many of you. But I must remember, I also have the law. Should there ever be a conflict between my code of ethics and the law, I must remember that the law always prevails. A few other things with our preamble state: identify and take steps to eliminate practices that may damage the public or which might discredit or bring dishonor to our organization. Use exclusive representation of our clients. There are a number of ways to do business, both on the listing and selling side, but we urge you to always seek exclusive representation to protect our customers and clients. There we are. Don't ever take any unfair advantage of a competitor. And most importantly, with a strong million-plus member organization, comments are always seen, comments are always passed. To uphold the integrity of our industry, we never want to make a comment about one of our peers. If we can't say something positive and uplifting, say nothing and change the subject. If we ever say anything about one of our million-plus friends, we're only damaging ourselves. There it is. If an opinion is sought about a competitor, make it positive, make it strong, move the customer on to another subject. The term realtor, the big R that we believe in and throw our shoulders back and are strong about, the big R, realtor, stands for competence, integrity, honesty, value, moral conduct in all of our relationships. A number of teachers here in the room with us and across the country, we always instill in our realtor members the proper pronunciation of that word. I'd like to just share it with you because you're my fellow instructors and we're the ones out on the road sharing about the code of ethics. So we are realtors. We're in the realty business. So let's say it together. 1, 2, 3. Realtors. There, you got it. We are realtors. Okay, remember also, money. No inducement of profit. No promise of a listing. No promise of additional business. Nothing should ever sway us from the path that we're on to protect the public and adherence to this code. Don't ever let any inducement of profit or any type of instruction from a customer or client ever have me depart from what I know is correct. The code of ethics has been good to me and to all of us in our business. It's helped me be successful. It's the thing that I'm most proud of when I'm in front of a customer or client. There's also something known as business ethics. Industry codes, company policy, moral values. These things play into our business every day. They may not be part of the law, they may not be part of the code, but they're part of our business. Legal standards, and of course, our code. We're going to take you on a journey today and go through a number of the articles in depth with our fellow instructors that are here to share specific articles. Carolyn Gardner and I are going to have a chat over a cafe table and discuss some items that I think you will find beneficial, and we're glad you're with us here today. Thank you for being here. Let's take that journey down the road and share with each other a number of our articles to the Code of Ethics. Why don't we begin with Article 12? Article 12 is our article that gives us guidance on advertising. And I think the way I'd like to approach it is let's talk about a few things that are not considered advertising, and then we'll go into exactly what is covered under Article 12. Good definition. Article 12 says, realtors shall be careful at all times to always portray a true picture in their advertising and their representations to the public. We have the additional duty to always ensure that our professional status is known. So if I'm a broker, property manager, real estate appraiser, I need to make sure that those professional statuses are always clearly identifiable. I first think about the Code of Ethics and advertising and my status as a realtor. I'm so proud to wear the pin. I wear it in all my business transactions. That's what separates me. I also make sure that that status is clearly identifiable on my business card. Why don't we take a minute and let's just pull out our business cards and let's see, do we all show that on our card we identify ourselves as a realtor? Do you have the large R, the registered trademark? If not, consider that the next time you place a business card order, and I share that with the consumer. National is doing an excellent job of running commercials and print media to educate the public about the difference between a licensee and a realtor. I read an article just last evening that showed the large increase in awareness by the public to use a clearly identified realtor. Distinguish yourself. There we go. That's what we are, realtors. Okay, so what's not, now that we know what's not, let's talk about what is not considered under Article 12 a little more. I'm working with a customer, a client, a customer. I wish to print out information from the multiple listing service and share. Well, our MLS rules allow participants and subscribers to duplicate, print, email, that type of data of a property to a prospect, and that is not considered advertising. Also, under our IDX, the Internet Data Exchange, where brokers allow other brokers to place information on their website, that is also not considered advertising, as long as, of course, that advertising is in compliance with the IDX rules. We like to think of Article 12 and advertising that once you look at something, put it through the truth test. Is what I'm writing in my advertising to describe a property, is it truthful? Is it honest? Is it a real representation of that property? So you might ask yourself, does this pass the truth test? Now, we've all seen those ads that are considered tacky. Someone saying, come work with Mark, the most handsome realtor in North Florida. Well, you know, that may not be truthful. It may be considered tacky, but it is not under the advertising code that it's not a violation. Okay, here's also something for the truth test. We may not do this, but it would be okay. What about us placing an ad showing our competition as compared to us and how much production they've done? Well, here we go, the truth test. Number of real estate companies, number of closed deals for the year, with a disclaimer at the bottom that says, this information comes from the North MLS and covers the time period from so-and-so to so-and-so. Well, as long as that's truthful, that's okay underneath Article 12 advertising. We may not do a lot of that, but it's okay as long as it's truthful and we've got the disclaimer showing the time periods where that production came from. How about active and pending sales? We all remember that the listings belong to the broker, yes? So anything that is active or pending comes under the jurisdiction of the broker. The broker's the only one that has the permission to advertise those active and pending sales. So, with that being said, how about look what's for sale in Wedgwood Groves? Number of properties, bedrooms and baths, and prices. And then look at the not correct advertising. Call Marcus Wally your Wedgwood Groves specialist at Coldwell Banker. Well, I don't think that's right. Unless Marcus Wally has all of those properties for sale, or he's been given permission by the listing broker, this is a violation. Let's go to sold. Our code that covers sold properties has changed over the years, and today, the broker that listed or the broker that sold the property is allowed to say that they sold the property and advertise it. So we can advertise properties that have closed or sold, provided that the representation is true. We're back to that good truth serum under Article 12. Only the listing and selling broker are entitled to claim that they indeed sold the property. So we have an example. Look what's sold in Wedgwood Groves. Number of properties again, bedrooms, baths, and the selling prices. But now he's done it correctly. Properties reported from the North-South MLS from the period November 1 of 05 to December 1 of 05. And here's the magic that keeps me in compliance. These properties were listed and sold by various MLS participants. For all your housing needs, contact your Realtor. That is permissible. This is a good ad. Okay, now, our market around the country has been strong in the last couple of years. We've been helping lots of people. We've also decided to get involved ourselves and buy and sell properties. We believe in it, so we've been buying and selling. We've been purchasing. We've been investing. So now it's time for me to sell my own property. Two ways to do it. Will I market my own personal property for sale by owner? Or will I place it with my brokerage firm? If I'm selling as a FSBO, or if it's listed with my broker. Which way am I going? Well, I've got some rules. If we're going to do it for sale by owner, we must remember that the public needs to know that they are working with professional people. They've got to know that up front. So how do we do it? We disclose that agent owner, broker owner, owner realtor. And I must remember, if I'm in property management, this includes rentals. Must disclose no blind ads. We would never want anyone to call a phone number and I pick up and I'm knowledgeable and I have expertise. They need to know when they call that phone number, they're calling a realtor, professional person. No blind ads. Okay, how about when I list it with my brokerage firm and I'm selling my property? Ownership interests of all sales associate and brokers associates also must be disclosed in the multiple listing service. And then, of course, prior to signing the purchase agreement. So in my multiple listing service, at the bottom, where it says owner, Marcus A. Wally, comma, licensed real estate broker. Perhaps I even put it in the remarks section, but definitely in the MLS, so anyone who pulls that data knows, oh, yes, that property is owned by a licensee. Then, when the time comes and the buyer is brought forward, once again, either at the top of the contract where it says seller or perhaps on an addendum. Marcus A. Wally is an actively licensed Florida real estate broker, period. I've complied with the code. I'm a good standing realtor. I've disclosed to the buyers that I own the property. Also under advertising, Article 12, I get excited about my business. I've got to be careful that we don't do something called puffery or exaggeration. I'm a salesperson, I'm a salesman, and I want people to know about my listings. But I must be truthful, so I need to be careful that I never exaggerate. I had an instance once where a wonderful family listed their house with me, and it abutted a city park in St. Augustine. I can remember the husband saying, "My children run and play in that beautiful grassy area. We have such a large lot." For me, to include the extra dimensions of that city park would be a violation and fraud. I do not want to mislead anyone to believe that our lot size includes that adjacent land that the city of St. Augustine owns. So exaggeration. I must be careful. I can be creative, but I must be honest. How about the word free? I see that quite a bit today. We're always interested in bringing people into our world, maybe with a free market analysis, comparative market analysis. What about, I'm offering a free home warranty to anyone who lists their property with me in the month of April. It's okay. It's okay to give away things for free. That's legal. As long as it actually is free, all parts of the free are disclosed and there are no strings attached. So we have those examples. Free market analysis, maybe a home warranty. I'll let you borrow my moving truck if you do business with me. As long as I've disclosed everything and it's actually free and the consumer understands everything, I'm good. Declaring sold, we mentioned that. It's changed over the years. Be careful today, only the listing and selling broker are allowed to declare that they sold the property. We need to be aware, if I had a listing with my brokerage and then I left, I'm not entitled to declare that I sold that property unless I have permission from the brokerage company that had the listing and sold it when I was there. Be careful about when we change and we move. Internet advertising. Our world today, we're successful because of the opportunities that the internet has brought us. But with that success and that exposure comes guidance and caution. Listings on the web are not my property. I think sometimes people believe if it's on the internet, it's global, it belongs to any and all of us. That's not true. Each association and multiple listing service have adopted their IDX rules, our Internet Data Exchange rules, which must be followed. Linking my site to Realtor.com is permissible, but if I were to use another association's name or another company's name or their URL, and I'm not part of that association and I'm not a member, that could be considered false advertising. I'm proud to be a member of the St. Augustine St. Johns County Board of Realtors. For me to take another association's website, their address, and hyperlink it to mine so that all that traffic comes to me is not right. If I'm not a member of that association, if I'm not a member of that company, using their domain name, which I'm not a part of, is a violation. Talk about business cards. We pulled it out to verify our status to distinguish ourselves as realtors. Well, the code does not regulate our business card unless, of course, it's not truthful. Article 12, advertising, something we use every day. Those are our good rules. Thank you. Let's investigate Article 4. Article 4 states, realtors shall not acquire an interest in or buy or present offers from themselves, any members of their immediate families, their firms, or any member thereof, or any entities in which they have an ownership interest, any real property without making their true position known to the owner or the owner's agent or broker. This is powerful, especially in this time where we're investing in our product. Immediate family. How deep do I take that? You mean when I'm helping my brothers and sisters and my grandmother, I need to disclose my status As a realtor, absolutely. Here's the good definition that NAR gives us of immediate family. How about myself, of course, my spouse, our children, our parents, our grandparents even, our grandparents, children by birth or adoption, and even grandchildren. Okay, well, it seems to be intense, but it's the code, so you know what? We do it. If I'm going to be involved with anybody in my family, in my tree, I disclose it. It's not that anyone is ever going to begrudge any of us from buying or selling property. They'll be proud. They'll feel good that we disclosed our status. So those are our guidelines when we talk about immediate family. Why the disclosure? Because we're knowledgeable, because we're talented, because we've gone to school and we have education and knowledge above the general public. They need to know that they're dealing with a professional person that has expertise. Members of the public must know we do have superior knowledge. When we buy, disclosing our status with this expertise is our duty. I'm writing an offer to buy a property of my own that I want to purchase. Marcus A. Wally is an actively licensed Florida real estate broker. It's never hurt me or endangered me from getting a property. I just disclose my status so that all parties are comfortable. For the protection of all parties, this disclosure should always be in writing. We're going to talk about that article today that encourages everything to be in writing, but most importantly, everything that we do with the public should never be relied upon as just verbal. Don't you remember I told you that I was buying it for my mother? Then I'm in a situation where I'm relying on verbal, and that's not the way to protect everyone. My duty, once again, to protect the public, let's put it in writing so there's never a misunderstanding or miscommunication. We're back to our good realtor membership and what we are so proud to be a part of in this great industry. And we should sing it out. We shouldn't hide it. Let's do a couple of questions, and you tell me how you feel. My assistant that's been by my side for a number of years, Gwen Lewis, unlicensed, wants to buy a property. Now, she works with me. Do I need to disclose that? Yes, you're right. I do. I need to disclose it. Works with our firm. That was part of immediate family. Let's do another one. The day before a divorce is final, should I disclose? Please. Yes, absolutely. It's the day before. We're still married. You're still my spouse. I must disclose. Spouses, part of immediate family. Let's do another one. What about girlfriends, boyfriends, or exes? Need to disclose? No. Good. Very good. No, not at all. A mom selling her son a home and tells the seller, we're buying this for my son. Good? Not good. Not good, exactly. And what's not good about it? It's that verbal part. We need to put everything in writing to protect all parties. Good. Article 4 also says that we should disclose our ownership in any interest that we may have to all parties. So I own some stock in a corporation that's thinking about selling a tract of land. That's ownership interest, even if it's a very small ownership interest. I need to disclose that. MLS rules require that my status as a licensee be disclosed in the listing paperwork so that when it pops up in the computer, all parties know, look at there, that piece of property is owned by a licensed realtor. Here's a tough one. How about this? Your wife owns a rental property from her previous marriage. I'm not on the mortgage or the deed. Do I disclose? Okay. Well, I think in that instance, little trick, it's not homesteaded property. Let's think about that. I married her. She owned the property. I'm not on the mortgage or the deed. It's not a homesteaded property, it's a rental. So when the property passes, I'm not going to automatically be entitled to that as if it were homesteaded property, correct? So that one makes me think. The answer would be no. The answer would be no. And it's that key word of rental property. I think for those states that have homestead exemption, perhaps if it was primary residence and homestead laws and marriage, but in this instance, rental property, I'm not on the deed or mortgage, no need for a disclosure. Okay, how about one more? An investment club that you and I are part of, deciding to sell a piece of property. I'm part of that investment club. I've got an interest. Do I disclose? Good job. Yes, absolutely. That would mean a disclosure. And then I'm selling my homesteaded property, my primary residence, and we all know that that is an absolute disclosure. Yes. Okay. I'm selling an investment property, a multifamily building, not my primary residence, so is the written disclosure needed? Yes. We didn't mention anything specifically about primary residences. Any property that a licensee owns, that status must be disclosed. Okay, and with that, thank you. Article 4. We have the privilege and honor to have a longtime real estate broker with us this afternoon. Her name is Linda Dix of Linda Dix Realty in Tallahassee, Florida. Linda has her own company, is a licensed real estate instructor, and we are proud to have her with us. Please welcome Linda Dix.
Thank you, Marcus. Good afternoon. Okay, folks, let's start all over again here, okay? We have been talking this afternoon about being so proud of being a realtor, haven't we? Okay, what is the number one thing that you think, and I've been in this business this month, is 26 years I've been doing this. I'm sure there's probably some of you out there that's maybe even been here longer than me. What do you think the number one thing, or one of the number one things is that keeps us going? Enthusiasm, folks. And let me tell you, when you're talking about the code of ethics, you should be enthusiastic because this is our livelihood. This is what we're all about. Are we proud to be a realtor? Yes. Okay, let's start all over. I'm going to say good afternoon again, and I want you to give me a realtor good afternoon. Good afternoon. Oh, I love it. Thank you very much. Now, let's keep that enthusiasm going here, okay? What we're going to talk about is going to be Article 1 and Article 2 during my session. We're going to